So I grew up in North Orange County and I was really excited to watch on another podcast an attorney who specializes in estate planning and trust litigation, which I always find an interesting combination, but he has a good background to explain why. Josh Ramirez from an attorney in Placentia, California. Josh, how you doing?
I'm doing well. How about yourself?
Fantastic. So,
Good.
I asked you before we started, and you gave me the story about how you got into both estate planning and litigation. How did that happen? It's an interesting combination. I normally find the estate planners more want to just sit in their office and be left alone. The trust litigators, they really want to go to war, and almost like football players in litigation. How did you end up with that combination?
Yeah. So, funny story. When I was in law school, about 12, 13, 14 years ago, I went up to a professor and I said, I don't quite understand the focus of the school. It seemed to be focusing on topics that weren't interesting to me. So she said, look at estate planning and taxes. And ever since then, it clicked. It was black and white law. So I was practicing for about 5, 6, 7 years, and one of my trustee clients got a letter from opposing counsel. After several months of letter writing back and forth and solving the issue, I realized I know what I'm talking about. I know how to litigate. I know trust law and the probate code. So I decided let me work on some litigation. The very first case that came into my door, it actually went all the way to trial. I won it, and that's when I realized I know what I'm doing.
Wow.
So I do now trust litigation and estate planning, which you're right, it is extremely unusual. Most estate planners kind of scared to go talk to judges, and most litigators don't want to sit behind a computer screen just typing out a trust. The reason we do both, to quite honestly, is the litigation makes me a much better attorney. When I do estate planning, I now know the most common issues that are going to end up in court, the very nuanced issues that are going to end up getting people upset, and we solve those in the planning phase.
I see that. In fact, I have to say that while I respect for business, you might pick one or the other or your personality. I see the ones who give me the most knowledge I learned the most on estate planning is because they litigated that issue and they either learned the hard way or the easy way. They know what the judge will accept or won't accept. They know where to push the line and they know where to back off. And I think that's what litigation tells you. And then you can implement that in your practice.
That's exactly right. That's exactly right.
So let's make it more practical. As a estate planner, you see common mistakes because you're litigating them and either telling your clients, hey, you have a problem, or you're litigating and the other side has a problem. What are the most common mistakes you see in estate plans that come to you or that you're involved with litigating? What do you see that the other state planner did and made a mistake on, or things that you've evolved with over time?
Yeah, I will tell you the almost the number one reason we are in court is joint tenant accounts or assets. What oftentimes happens is mom and dad set up a trust back in the 80s, 90s. Everything's great. And then they decide, I'm getting older. I'm going to add my son or my daughter on my bank account to help me out. Well, when they passed, they thought that that account was going to be divvied up to the kids, but legally, that goes to the surviving owner.
Right.
And that ends up in court all the time. Siblings are hurt, siblings are angry. The allegation goes typically the intention was to use that as a quasi trust account. And that's what we litigate very, very often. Joint accounts. The second number two reason we're in court often is lack of disclosure, just lack of communication. Beneficiaries don't know what the trustee is doing. They're not being communicative about the realtor and the listing and the open houses and how much money there is. We're in court. So I'd say that those two reasons, well over 50% of our cases are those two reasons.
So I see the second one because that more affects me, obviously, where the heirs will say, my sister, my brother, whoever isn't keeping me informed. As a real estate agent, my client is the executor and or the state. That's an interesting debate you could have, but clearly my
Right.
client's not the heir. So what do you instruct, or do you, as far as real estate agents, how much information should they give to heirs who are not the administrator or the trustee?
Yeah, so I would tell the realtor that it's generally uh, not their concern to be talking to the beneficiaries. The best advice a realtor could give their client is consult with an attorney and follow the rules, follow the
Yeah,
law, follow the
yeah,
book,
yeah.
and that will include things like disclosures, giving your listing agreement. So let the attorney handle all the right disclosures. But yeah, that's the advice I would give realtors.
And
send
then
your clients to somebody like me.
now, too often my clients are involved with somebody not like you, where the attorney is not, as communicative as the customer is expecting or as the beneficiaries are expecting. And again, I guess the only thing I can say is really, I can't help you. You need to go to the trustee. That's their job. And I'm glad to remind them separately, but that's not really my position to discuss those details. Is kind of like the right way to say, or
That's exactly the right way. And you identified an important point that sometimes people just aren't communicating. And we also have to look at, is it the trustee, excuse me, is it the trustee executor who's not communicating? Excuse me, or is it the attorney who's not communicating?
Right.
Oftentimes it's attorneys are overworked.
Yeah.
Attorneys just aren't getting back to beneficiary questions and people blame the trustee. Unfortunately, all the blame will fall on the trustee. You have to choose an attorney who has the time and energy and will respond. And so if beneficiaries are getting mad at a client's for not responding and they have an attorney, it might be time to have a conversation with the attorney.
Yeah, and I think also sometimes the expectations that the trustee and attorney aren't lined up. As a real estate agent, we're used to responding within minutes typically. Customer texts me, unless I'm in a meeting like this, I'm responding right away. And many agents will respond in the middle of a conversation, but attorneys don't. If you're in court, you really can't. I was in court this morning online. I really can't respond to a phone call. And so I don't think customers understand there's a mismatch in the ability to communicate. And I think also tactically, there are times when you don't want to communicate. You don't want to pass on the bad news you're not obligated to until you have to, right? And that's another issue. So, okay, so that's on a straight trust. However, I get phone calls. I'm sure you get some of these, but I get some and try to not send them to attorneys like you, where I just feel like there's an upset beneficiary, but there's not enough money really to hire somebody, right? Because litigation is expensive. So how do you describe what's the threshold at which it becomes worthwhile for them to pursue it? To me, anytime you tell somebody to write a check, the intensity of their complaint goes down quite a bit. How do you must get phone calls from beneficiaries saying my brother didn't do this or my brother's doing that. How do you explain the process and what's the threshold to do something?
Yeah, well, I'll give you a direct answer that most attorneys won't. I would probably say somewhere in the ballpark of 150 to 200 grand. If that's the prize money or above, it might be worth pursuing. If we're looking less than $150,000 of your inheritance or what we're trying to recover, it's generally not worth it. And I have numerous consultations, 100 a year, where I tell clients it's just not worth it. I will take your money. I will go to court, but you're going to spend more money than it's worth. You're going to throw good money after bad. And clients appreciate that, of course, when I counsel them correctly. But oftentimes attorneys counsel the opposite and rile people up. So it's important to have a good look in the mirror and truthfully analyze what things are going to cost, what's your prize money, and what's the realistic possibility of you winning. Not just your story, and are you upset with what mom or dad might have done, but what actually happened.
Yeah.
So it's a hard analysis, and sometimes you have to just throw money at it and see. Sometimes you don't know all the details. I oftentimes talk to kids who are living out of state. They don't know what happened with mom and dad here in California and the local sibling. And sometimes there's no answer. Sometimes it just takes time and money to figure it out. Yeah.
Yeah, I do see attorneys who kind of, it's almost like a cockfight. They push the two parties together to get them riled up to spend money. And I see on the other hand, people who, it's interesting you say a threshold, because I have another trial attorney I interviewed who had a much higher threshold. And some of that's their cost and their practice and their willingness to pursue it and where their business is. So I appreciate knowing that as well.
Yeah, and it definitely depends on the fee structure. Are we talking hourly, contingency? There's various data points that go into that answer. Right. But that's on a traditional case. If somebody says, is it worth hiring you on an hourly rate? You got to be getting a couple $100 grand out of this. And that's because we also don't price gouge our clients. A litigation from us does not cost $200,000, $300,000, $400,000. It's not that kind of ballpark.
Well, now you're located at Placentia. Is your litigation business strictly Orange County courts? Do you go to LA County as well, or is it split evenly, or how does that work? Or
Yeah, so
the other way?
Yeah, we practice in all of our touching counties, so Riverside, LA, San Diego, and Orange County, and San Bernardino. Those are our regular counties we practice in. We do practice in counties in Northern California occasionally.
Hmm.
The honest truth I tell clients is sometimes it does make sense to hire local counsel. Sometimes it makes sense to hire the guy you like or the gal you like, and who's going to do a good job.
Right.
And so that's how we do get cases up in Northern California.
One of the advantages, I used to live in Diamond Bar, which is just over the hill from Placentia, is you really are at the touch point of 4 different counties: LA, Orange, San Bernardino, Riverside. And I think the nature of people there is to go drive a little further than it is for people in West LA. In West LA, we wouldn't even imagine going to the Valley for a matter, which is the same city.
Right.
But when you live in Placentia, yeah, you go to San Bernardino, and it's just a different mindset. So let's talk about estate planning. What do you see driving any changes in people's willingness? Do you see COVID as being a driver to get people to really evaluate these things and take advantage of it? Or is it just the same old people putting things off too long and they should have done it 2 years ago kind of thing?
Yeah, there was a little boost that I saw of people more interested in estate planning when COVID hit. But on the other hand, it wasn't as big of a boost as you would think because people were still a little uncertain of the future,
Right.
uncertain of spending money right now before we don't know what's going to happen with the economy, uncertain of meeting people. Well, that was at the height of the masks and freaking out. So, but there was a boost. I'd say that the biggest uh, trigger that triggers people to call me is unfortunately the death of a spouse. We're oftentimes establishing a trust for the first time for a widow. Um, Now we don't do that right away when a spouse dies. In fact, we beg people to call us in a few months. Take some time to grieve. Um, but that's unfortunately a very common scenario. A spouse passes and people realize it's time. The other most common scenario is the parent passed and we're in probate, or they only had a will, or they had joint accounts, and they see all the problems that occurred,
Right.
and they realize we're not going to leave our kids with this problem. We're setting up a trust.
I wish in probate court they required at least a basic estate plan set up at the end for any errors. That would just seem to me, let's end this game going on. I literally was in a court matter in LA County online today where it's a conservatorship, which means they didn't set up an estate plan. And then years of litigation from 2016, years of litigation go on. They never settle it. Their property's never sold. The conservatee passes. So for a
Yeah.
year, the attorneys are dragging out, and really nobody stepped up to file the probate to take over. I guess in conservatorships, you can't do a special administrator like you can in probate because the court wants a new administrator, and nobody stepped. And the attorneys are just collecting fees, and the family's upset, they're losing money. And I kind of pushed one of them to file a probate, but it's amazing. If you don't do it ahead of time, you're going to pay a fortune. It's going to be ugly. You're going to hate your spouses and your siblings and your friends. The whole thing is just a mess.
One of the most common things I say in consultations is, if we do this, you're going to lose a sibling forever. Are you sure about this? Are you sure you want to sue? Because that's the saddest part about the litigation. It's not the money that stinks, but it's you lose your family forever over nonsense most of the time. Yeah.
And I think even if a parent doesn't have a lot of money to leave as a legacy, at least leave the plan so you leave a legacy of peace amongst your kids and family. Like to me, that this is maybe as you, there's some discount estate plans, and I know generally attorneys say they're not good. We could disagree. I would say 90% of those bad plans are better than no plan. The 10% are
I- I'll, I'll
litigation.
be I'll be one of the lawyers who will say I agree. A bad plan is better than no plan. Occasionally, though, a bad plan could enter in way more litigation than if you had no
Yes,
plan at all.
no
The bad
question.
plan, we move into elder abuse and how it got signed versus
Yep.
just probate it. So
Yep.
so sometimes, yeah, a bad plan can be worse, but
Yep.
yes, I prefer a legal Zoom plan over nothing.
Yeah.
To be quite honest, you identified the probate and conservatorship issue. I will say that our courts, especially in Orange County, are very good. One of the best in the country, I believe, for probates and conservatorship. They're honest, they're on it, they're honorable,
Yeah.
they know their stuff.
Yeah.
But no matter how good the court system is, probates and conservatorships, they stink. They are not something you want to do if they can be avoided. And that's so simple to avoid by seeing an estate planner like me. All of the court stuff goes away. And the funny thing is, it's attorneys that kind of joke about it internally because to set up a trust, people think it's a very complicated issue, very expensive, 6 months process. It's really about a month process. Two, three, $4,000 is the average price from a lawyer in LA and Orange County. Versus the 10, 20, 30 grand your family's going to pay after you pass in probate.
At
So
least.
spend a couple of grand now and you're done forever. You shouldn't need a conservatorship or a probate in the future if it's done right.
And even if you own a house, you really should have an estate plan.
That's the triggering factor.
Yeah,
for sure.
For sure. If you have kids, you should set up, because who's gonna take care of the kids if, God forbid, something happens to you? And I just tell people, either one of those, if you have minor children and or a house, you have to get one. Have to. There's no debate. There's no discussion. Get it done. I don't care how. Yes, good attorney is better than a template, 100%. Get it done. And you can always bring the bad plan to the good attorney and redo it. Like, there's no law that says you're stuck with it forever. It's not closing the door, right?
Totally true. The funny thing about people with minor children, I have minor children, so it's near and dear to my heart, planning for guardianship issues in case I pass when my kids are young. And one of the things I talk to clients about is, it's funny because when you're young and you have kids, you just bought your house, you're not thinking about setting up your trust and spending an extra few $1,000s that needs to go to the mortgage. I totally understand that. I'm there in that phase of my life now. On the flip side, though, it is a little bit more complicated for a young family because I bring up issues as an example. People usually say, well, we want my brother and sister-in-law to be a guardian. Easy solution. We can go on LegalZoom to do that. But what if they got divorced? But what if they got drug habits? What if? And there's so many issues that clients don't think about without a lawyer that you realize, oh, I would not have wanted my kid to go to my sister-in-law if they got a divorce. That doesn't make sense.
Right.
Or, oh, you're right, they are a different faith than I am. That doesn't make sense. Their economic status does matter. Right. So there's a lot of factors we pull out with guardians and minor kids. Yep. Then that doesn't even talk about how are we going to give them money in the future? Right. What ages? What's the formula? How do we make sure we don't give an 18-year-old a Porsche? So there's a lot of things to discuss with people with minor kids. But they're near and dear to my heart, and I love working with folks with minor kids.
Well, I have pushed we only have one child, she's married, and we have 2 grandkids. I said, look, we have to, I don't care if you write in the other grandparents or your siblings. I don't even care who it is. Just it better be a name of somebody that you trust to take care of my grandkids if, God forbid, something happens to 2 of you, because we don't want to be litigating over this. We don't want it to be unclear. We don't want to be fighting over it. It's tough enough.
And that's the main point. What'll happen is the wife, the people who have equal priority to be guardians are the wife's parents and the husband's parents. So now you have 4 people with priority to be guardians. And truth be told, none of them are probably going to be a good fit because they might be aged out from being a good guardian for a 10-year-old, right? You need to consider age and going to amusement parks and playing sports. Those things matter. Right. And so oftentimes maybe even the parents isn't the default we want, but that will be the default if we don't do anything.
Right.
And oftentimes,
I don't really want that job. I'm willing to take it if you need me to do it. But whatever it is, let's get it in writing so we're not arguing about it. That's the number one. I could live with a bad decision. What I can't live with is no decision, because then we're stuck fighting over, or my wife fighting over it maybe, or my in-laws or something.
That's exactly right. And often I give some very nuanced advice. And an example of how I solve these problems is sometimes we might put the grandparents in charge of the kids' money, but we'll put somebody younger to be the guardian. This way, the hands aren't in the cookie jar. We've isolated both. The kids can have a nice younger parent that can take them out and do activities, but also somebody financially wise to hang on to the cash.
Yeah, my 2-year-old grandson, I could not take care of him all day long. A couple hours, I'm like ready to fall apart. So I'm with you 100% on that.
Right. Yeah. Could you imagine being a parent for another 16 years?
I mean, you do what you have to do, but
right.
Fortunately in my life, I've got siblings, and my son-in-law has siblings. And so the answer is there's probably better solutions. Let's just get it in writing. What we don't want to do is not have an answer, and then me and my wife and my son-in-law's parents have to decide, because it could go well, but it could be ugly. It's not necessarily, where the kid's going to live means who's living closest to them. And that's a whole.
That's just it, though. Yeah.
Common litigation, I see that one all the time too. Look, Josh, I go on for hours. I really appreciate the time with you. For anybody
course.
looking for estate planning services, sounds like you're affordable yet practical solution there, or trust litigation issues, particularly in North Orange County, but really all four of the Southern California counties. What's the best way to get in touch with you and find out about getting started with you?
Yeah, you two ways to get in touch with me. If you want to go to my website, the name of my firm is California Estate Planning Services, CaliforniaEstatePlanningServices.com, or you can call me for a free consultation at 714-584-5009.
And we'll have the information in our notes in our description down below. Josh, thanks so much for your time. Look forward to speaking with you again soon.
Thank you, Bill.